Alrighty, let's start. Good evening, participants. Today we have with us Mr. Rakesh Ojha. He is senior partner at Asia Law Offices. After completing his BA Honors Economics and LLB from Delhi University, he got admitted to the bar in 1995. Mr. Ojha is an experienced corporate commercial lawyer capable of rendering advice on the broad spectrum of legal problems confronting business in the contemporary Indian environment. His career has spanned a range of legal areas over 2 decades. He specializes in mergers and acquisitions, corporate finance, infrastructure, especially real estate, power and telecommunications, IT-enabled businesses, including outsourcing and human resource law. He also advises on IPR. His corporate reorganizations and restructuring practice gives to him extensive experience of all court-centric actions, procedures, and practices. He manages all corporate and commercial litigations at different levels, from the trial to the Supreme Court of India, and leads all interactions with external court counsel. He is experienced in leading tribunal-centric litigations, including the company law boards and the antitrust tribunals, and has an excellent track record in domestic and international arbitration and dispute resolution. We are privileged to have you, Ojha ji, and the participants are actually looking forward to the discussions and sharing of your experience and insights from you. So over to you, Ojha ji.
Thank you. Thank you, Dr. Siroi. Thank you so much. Good evening, everyone. Welcome to this session. As we all say, that may all of us remain safe and well in these times. And thank you, IICA, for providing me the opportunity to talk to my colleagues here and share whatever we can contribute to this particular program. Indeed, it's a very valuable program on valuation that IICA has been doing. So with that, broadly, I know the way that this program, the curriculum has been going, and my area, my interaction with you gentlemen today and tomorrow would be broadly focused around valuation of shareholder rights. So we are talking of enterprise valuation, and from there, what is the paradigm in which we discuss or we consider when we look at individual or collective shareholder rights. So that will be a broad subject that we will together try to canvas within the time that we have. Now, before we get into the subject, I would like to make few very, very preliminary statements. This would be the guiding principle through what we talk later. I will be primarily focusing on the legal aspects of attached to shareholder valuation. So that will be my primary area of discussion. I will not be talking too much on the financial and the quantification aspect, and I believe that there are very eminent experts, who have been talking to you people and would continue to do so, and they will deal with those aspects. Now, when I deal with the legal aspect attached to shareholder valuation, we would consider the law, the applicable law to this situation, the regulations, the regulations which attach to a company, corporation, or enterprise, and the contractual paradigm within which a company may or the shareholders may operate. And these contractual, paradigms, and the regulations and the law, they all relate to the enterprise or the ownership of the enterprise between the stakeholders. And we would consider through this discussion as to how these three aspects interplay to impact shareholder valuation. What are the features there? What are the aspects that cast some kind of a requirement upon you gentlemen as experts to bear in mind when you are trying to analyze shareholder value? May I also say that in this aspect of the literature, we find more clarity and more authority in international law than within the national law of our country. And it is only natural because the valuation as a principle, as a field of study and analysis has had a historically has had a much earlier start in the international paradigm. So today, when we will be talking about certain aspects, I will be drawing heavily from the principles of the economic valuation from international authorities. The applicability is rather universal. Even Indian courts and jurisprudence is now employing these in the valuation exercises that are being looked at or that are adjudicated. So we will draw guidelines from these international authorities. The next thing is that everything that most of what I would talk and I would discuss with you, it is supported by law, authority, or legal or judicial precedents. So there is a backing, there is a basis to what I would talk. I would at the specific places I have tried to indicate the authority, or else I would in any case share the list with you at after this presentation, and it will all be available with you. Now, and we will start from the point where you have now arrived at the enterprise value by employing one or more of the methods of valuation, and you have come at some kind of a equity value or enterprise value at the top level. And now you have to reach at the shareholding value of the interest or the holding in the enterprise. That is which is the subject matter of your valuation. So you have through your methods and what the experts have spoken with you, you have reached the enterprise value. Now you would transition from there to reach the value of that block or that group of shareholding. And one final comment: it's not necessary when I talk about it to take notes. I will share my entire reading material and case law lists, everything with you, so it will all be available to you. We would rather keep it more interactive and in a discussion format. Now, within the presentation or within the discussion that we will have, the areas that I would wish to touch with you or cover with you. Broadly, these are the 10 or 12 areas which we will cover. At the outset, I would indicate to you the broad legal framework which is relevant to shareholder valuation and application of discounts, premiums, etc. in that process. So we look at what is the legal framework in which we are operating, what are the laws, regulations which we need to bear in mind when we are considering the shareholder level valuation. Then I also, all of you are eminent in your field, but I would also introduce the concept of shares and shareholder rights in a corporation or enterprise. The reason I would do so because we need to understand the application of the valuation principles basically are very intricately linked to the concept of shares and the rights attached to those shares, or a bundle of shares, or a group of shares, or a block of shares. So we need to identify this. It's a very basic concept. We will talk about it and then move on, but this needs to form the framework. Then I will take you to the contractual paradigm, and I will talk about a little bit about the features, aspects, and terms of shareholder contracts or shareholder agreements or joint venture agreements or pooling agreements. These are various names, terminology which are used in the concept of shareholder association contracts. So we will look at that, and we will try and cite as to what is their relevance in the context of valuation of shares or a share block that they represent. So we will look at shareholder agreements, broad features, and how these interplay in the valuation process. Now, the moment I talk of shareholder agreements, in law, we have to deal with another aspect, which is the articles or the regulations of the company, and the applicable law which attaches to the company. Now, there has been fair amount of jurisprudence, fair amount of debate, discussion, fair amount of talk on these on the interplay between shareholders agreement, articles of a company, the Companies Act, and all that. So we will try and establish some principles and features to complete the legal framework attached to the corporation. Thereafter, we will go and look at the shareholder rights, both in law and in contract, and how do they impact the valuation analysis. Having done that, then we will come directly to the concepts of discounts and premium in shareholders valuation. So we look at the authority, the legal and the valuation principle which guide these discount and premium analysis. Specifically, we'll then go to the marketability or the transferability of shares and talk about the application of discounts for lack of marketability. In short, as you gentlemen know, DLOM, that's what is referred in your word. We'll talk about DLOM and marketability and how it is applied. Then we will take up the control aspects attached to the shareholding interests and how they are applied in the context of valuation of that interest in the form of discounts for lack of control, or DLOC, as you gentlemen would know. Having spoken of DLOM and DLOC, we would then try to interface these two concepts and look at them together in the context of shareholder valuation. How do they interplay with each other? How are they connected? How are they different? And what aspects and how should you apply them? So we'll try to reflect them on each other. And finally, I will give you some introduction on the status of the Indian law on shareholder valuation and discounts. Generally, what have the courts said in India? I'm afraid that there's not much, which could excite you people, but there is something, and it's a developing area surely. And finally, in the last part, I will also introduce you some international authorities around discounts and premiums, and then we'll sum up with some conclusions what we derive from our discussion. And I would then give you the list of reading material and what is relevant to my presentation. So this is what we are going to talk today, and whatever remains, we will pick it up tomorrow. Now, taking the first aspect, and one more thing, while I am presenting, I can take the questions, but I would prefer if the questions are taken towards the end of my presentation. We will keep some time today and tomorrow both. So just for the sake of flow, we'll go ahead. You gentlemen can note your questions, issues. We'll try and address them as towards the end of the presentation. Now, the first aspect is, what is the broad legal paradigm in which we are operating? Obviously, we are talking of a company or corporation or an enterprise. That's where we are. And it's very clear that all of us know that the old Companies Act of 1956 and now the new Act of 2013 forms the overriding law. Of course, there are regulations from special institutions like SEBI and all that, and also FEMA. We will touch on them. But I would say the mother act and the mother legislation which surrounds a company is the Companies Act, and that's fairly simple. One of the salutary principles of the Companies Act, which is codified in Section 6 of the new Act and earlier in Section 9 of the old Act, is that the Act will override any provisions of shareholders agreement, contracts, memorandum of associations, or articles. So there is an overriding, all encompassing power of the Act. What does it mean? It means that if a test is applied to any of the terms of any the articles, MOA, or such other agreement to which the company or the shareholders are party. And if any provisions of these documents are contrary or repugnant to the provisions of the Act, they will be read down. They will be held as repugnant and void as compared to the Act. So keep this in mind that there is an overarching impact of the Companies Act. Anything contrary there would have to fall in within this framework. Now, what is contrary to the Act and to what extent things are contrary to the Act is a matter of debate. And we can, at time permitting, we can talk about that at some stage. But let's make the statement and move on. Now, as I said, that we would get into the shareholder rights valuation and all those aspects. But let us, for the purpose of our discussion, let's try and understand how are we looking at shares and what is the concept. I mean, we all know what shares mean. I mean, something very basic, elementary. But even at the cost of repetition, let's remind ourselves that what is the concept of shares or shareholding in an enterprise. And the reason I say this is that since the underlying object of valuation is the equity interest in an enterprise, which you gentlemen would undertake. So we need to highlight some aspects of shares of the company, basic but very important. The first thing that we all know is a share is a right to a specified amount of share capital of a company, which carries with it certain rights and liabilities, while the company is a going concern or in case of winding up or liquidation. Now, this is a very, very simple universal definition in the seminal work of Companies Act, like Palmer, Halsbury, Pennington, everybody holds this. Now, let's see, what are we saying here? So, it's a right to a specified amount of share capital. It has certain rights and liabilities in law. These rights and liabilities exist at the time when the company is a going concern. These rights or liabilities also exist when the company is being wound up. So that's one concept. In terms of its nature, shares are a movable property and transferable in accordance with the articles of the company. This is a very simple principle under Section 44 of the new Act. So it's a movable and a transferable property. And also, for the sake of completeness, we have something called the Sale of Goods Act. And there, the definition of goods includes stocks and shares. So that's what it is from a legal framework. Of course, these are the personal estate of the shareholder, transferable in terms of the articles, and not in the nature of real assets. When I say that, I mean immovable real assets. So that's the feature, something that attaches to shares. That's the concept. And when we test it, the valuation analysis will test it with respect to these features and concepts as to how they come up for analysis. Obviously, the financial benefit of ownership of an interest in a business enterprise comes from three things. So if you own an interest or a shareholding in a business enterprise, your financial benefit or the holder's financial benefit broadly fall under three heads. If there is a declaration of dividend, there's a dividend distribution, that's one. Sale of your ownership interest. So how freely or how able are you to sell or transfer your ownership interest and convert it into liquidity? And finally, your benefit in the liquidation of assets. These are the three benefits which attach to to the quality of the shares that we hold in enterprise. Now, I think at this stage, when we have spoken a little bit about the shares, it could be useful to now introduce to you the concept of shareholders agreement. We will build on it as we go, but let's kind of quickly look at it as a concept as to how what does it mean, and what these cover, and to what these extent these are legally effective, binding, those kind of things. Basically, we all know that shareholder agreements are contracts between shareholders on matters concerning the company they own equity interest in. So, shareholders, one or many group of shareholders may get into these contractual arrangements. Those are shareholder agreements. As I said earlier, it's the nomenclature varies, across various countries. Even here, nomenclature varies, but essentially, whatever be the name, if there's a contract which is governing the rights and duties of the shareholders or the company, that's the shareholder agreement. I may also make a statement that a company, the underlying company, the shareholders of which have entered into this document, the company may or may not be a party to a shareholders agreement. And there are different implications of what could happen if a company also was a party to the shareholder agreement, or it was not, and we will deal with this as we go along. Now, key features, certain things which you, before we get into shareholders agreement, you need to understand that the ecology in which a shareholders agreement operates and functions. Agreement operates, exists within a contractual regime between the parties. So it binds the parties to the document, and within the realm of law of contract, it has its legal sanctity. And we all know the Companies Act does not provide or mandate a shareholders agreement, except for at very few places where you can use this document for filing and amending articles. But that's a very minor. But otherwise, you can take it that there is no mandatory requirement that shareholders have to have an agreement. Now, when this shareholder agreement finds reflection or incorporation or finds mention in the articles of the company, it puts third parties to notice, and thus gets a legal protection. So usually the principle of law of contract is that a contract always binds the parties to the contract. So there would a contract would not provide a right or cast an obligation to third parties who are not signatories to the contract. But the exception that I'm trying to draw here is and indicate is that if this shareholder agreement is found in the articles, and we all know that articles are a public document filed with the registrar, and tomorrow if we are going to either value or deal with the shares of this company, by being in articles, I'm put to notice that look, these provisions are there. So I cannot then claim ignorance or lack of knowledge of these terms of the shareholder agreement. I would say a very basic due diligence should reveal this aspect to the whoever wants to look at these conditions. Now, as I have already discussed, the only limit in law to a shareholders agreement is Section 6 of the new Act. That means shareholders in a contract cannot agree between themselves anything which is contrary to the terms of the company. So that's the limit. That's where a SHA will have to bow down. Another, legal limit is, and this is again, this has been a subject of a lot of debate, but it's fairly clear now that shareholder agreements cannot override shareholders or directors' legal and fiduciary duties. As we all know, the Companies Act and various other legislations clothe the shareholder or the directors with certain legal and fiduciary duties towards either other minority shareholders or all shareholders. Now, you cannot divest these duties or fiduciary duties by SHA. You cannot get rid of them. So that's also some kind of a limit. Now, if you gentlemen were to look at any shareholder document or agreement, I mean, broadly, you would find that shareholder agreements extend to three aspects. Of course, there are other minor clauses, but broadly, three aspects are covered. First is ownership and transfer of shares. That means how would the signing parties own the shares? What will happen if further shares are issued? And what are the manner, method, and the restrictions or conditions attached to transferability of shares? So there are various clauses in a shareholders agreement which address the ownership aspect. The second aspect which any shareholder agreement would look at is the covenants attached to the management of the company as to how do we as one or many shareholders, how do we agree that we would manage the company? How would we operate the company? So there are various aspects of management. We'll come to that. But for now, just bear in mind that management is the second aspect. And the third aspect that any shareholder document or a contract generally addresses is the aspect of corporate control. Control manifests itself in many ways, in many forms. In some examples, we know are those positive consent, veto items, and all that. We'll come to that. So, and then of course there are some certain very general clauses in law with which we have our representations, warranties, indemnities, dispute resolution, and all that. So I'm not; those are not relevant to our subject here. So, gentlemen, please bear in mind ownership, management, control. This document governs these three aspects around the shares. Also, keep in mind that to the extent that contractual terms of the shareholder agreement are not in violation of the law, they are in addition to the statutory rights in law. That means if there is a covenant in the shareholders agreement which is contrary to the Companies Act or law, it will fall. There's no doubt on that. But if it is not contrary, if it is just a supplemental, then these rights are in addition to what is available to a shareholder in law, the statutory rights. So really, a shareholder who is bound by a shareholders agreement then can exercise statutory rights in law and also the contractual rights which are there in the shareholder agreement. So that's the uh, now very briefly. I mean, I would what are the I mean these are the three aspects of but within that we can touch on some of these important. So what are the bespoke terms of a SHA generally? What would it have? As I said, within ownership, it will provide for manner and terms of ownership of shares and whether the optional versus the mandatory buyback of shares of the company in the event of shareholder gives up. In transfer, it may provide for right of first refusal. That means that we all know that if an existing shareholder wishes to divest its share to a third party, it will first offer it to the other existing member or shareholder and seek a refusal on the same terms. At times, this is also called ROFR or ROFO. ROFO means that it ends at the offer. ROFR means it ends at the refusal. So, in essence, this is a condition which is attached to the transferability of shares. Then it could typically have tag-along rights. Tag-along rights means that if a majority shareholder wishes to share its sell its shares or transfer its shares to third party, the minority has the right to offer its shares also tag along with the majority. So it's basically a provision which provides liquidity or marketability to the minority shareholder. The converse of that at times we find are the drag along rights. You know that if somebody wants to buy absolute control of a company, then the majority may compel the minority shareholder to sell along with them. So those are drag along rights. Of course, then we have the buyback rights, the shares. And then two more things usually we find the call option and the put option. Again, these are aspects which are very relevant to the marketability of shares. Call option broadly means that you can compel at a specified number of shares or a predetermined price. You can compel a shareholder to sell the shares to you. Put option is reverse. You can put the shares to the other shareholder at a specified date or a specified number of shares or price. So these are kind of restrictions on the freedom to dispose shares and other things. So these are the ownership aspect which are there in any bespoke terms in a shareholders agreement. As I said, the second block was operation and management aspect. How does it manifest in a shareholders agreement? It's fairly usual, normal for minority appointment rights. You could have a board representation. You could have specify a quorum for a board meeting. Your presence would be necessary. So some kind of a contractual mechanism which secures certain management participation and role to the minority shareholder. Now, this would be relevant in the context of control and delock, which we will talk later. At times, there are key management position appointment rights between shareholders. Also, the manner, timing, and the process of meetings of boards and shareholders. These are also generally there. Then you have the information and audit rights. Now, this is also very important in the context of our shareholder value, because if you indeed have your shareholding has information and audit right, then you would it would tend to such rights reduce the delock. Generally, we will come to that, but it's important. And then, of course, another way of management participation is that parties at times define, agree, or iterate a business plan for the company. They append it to the shareholders agreement. They then oblige each other to on a best endeavor basis to try and work. So then you monitor the business plan. These are some of the ways. Finally, coming to the third package that I said, the control aspect. As we said, the first thing is the minority protection rights. That is, what are the protections that a minority block of shareholder has? It could be vetoes, affirmative action, positive action, or negative list. These are all various ways that it is couched. Basically, what it means is that there are certain very critical decisions of the company which cannot be taken or bulldozed by the majority without some kind of affirmative decision of the minority. So those are the rights. And as I said, it manifests in various ways. Then there are rule it or other forced sale process. This is a mechanism to address a situation where there is a deadlock or a falling out between shareholders. So then this is how one party can compel a forced sale. And then finally, you have certain restrictive covenants like lock-in, non-compete, non-solicitation. So these are the aspects which are there on control. So that's the framework. That's the paradigm in which this any shareholder agreement generally operates. As we all know, there could be variations. There could be certain other very unique terms, but and which would then require a very specific analysis by you gentlemen. But let's stay with the what the universal kind of a framework looks like. Now, another issue in law, and which I need to kind of address at this point is that, and you would have read it in the last 15, 20 years or maybe before that there's been a lot of discussion of the legal effect, enforceability, the impact of shareholders agreement vis-a-vis the articles of the company. Now, these are two separate documents. One is contract, other is in the realm of Companies Act and regulation. And there has been a lot of discussion in Indian law around this. Let's see what is the legal effect of the articles first. In terms of Section 10 of the new Act, the provisions of the MOA and AOA bind both the company and its members. This is the first aspect that you have to keep in mind. So it's a contract of membership having legal sanctity. So a member shareholder who holds share in a corporation takes the share subject to the terms of this. So this is a contract implied in law. Two of the most common provisions in the articles of private companies, which you would have these are again very standard terms. Is the board or the director's power to refuse a transfer. It's a unique feature of private companies that the board directors may, if they have a power to refuse a transfer of shares. So those kind of restrictions are there. I may just put one caution here. Generally, there has been a lot of debate around this aspect of a board's refusal, even in a private company. But the law is that the exercise of such power by the directors or the board, it has to be in a bona fide manner. It should not be arbitrary, and the interest of the company and the shareholders are paramount. So any colorable or a collateral use of such power becomes a subject matter of a judicial dispute or a review. So that's the general law that although you can have restrictions, but it's not that you have an inherent power to refuse. You should exercise the power in the interest of the company. The second most common provision in articles that you would find here are preemptive rights of shareholders. That means, in very simple terms, if further capital shares are issued, they would first be offered to the existing members on the defined terms. So these are very two general aspect of the articles. Now, if you interface a shareholders agreement and the articles of the company, the position is that the shareholder rights become stronger and legally, much more credible and enforceable against the company if the terms of the SHA are incorporated in the articles of the company. So, if either complete or partially or to the extent that the shareholders agreement terms are embodied in the articles, the status of the contractual rights is enhanced to some kind of a legal protection against the company. So keep that in mind. Now, in this context, of course, there has been a lot of development, a lot of discussion in Indian law over decades, and there are some very few seminal cases I will indicate without getting into it, just to derive the principle and to indicate to you, gentlemen, how this particular part of jurisprudence has developed. One of the earliest cases we find of the Supreme Court is the Shanti Prasad Jain case of 1965, and where it was very clear that a company is not bound by a private shareholders agreement. And since in that case the shareholder agreement was not incorporated in the articles, it was not binding on the company. Even the shareholders agreement did not provide that the articles will be amended. So on this principle, the Supreme Court had said there that there was no transferability restriction of the company in its power to dispose of shares, because these restrictions were not there in the articles. That was one of the first cases. And then we come down, almost 25, 30 years later, and this is a very famous case. All of us know that the issue started from this case, and then this is the Rangarajan case. It's the famous VB Rangarajan case, 1992 Supreme Court. Very short case, but with led to very long discussions in later cases and distinguishing these cases. It's really a branch of company law. What the Rangarajan case said was very simple. Articles of association are regulations of the company, binding the company and its shareholder. So we already spoke of this a little while ago. Shares, by their very nature, are movable property, and their transfer is regulated by the articles of the company, one, the Companies Act, and the Transfer of Property Act. So this is, now we did speak of transferability in terms of articles. We did speak of the Companies Act, and I did say that it's a movable property. So this was the law that they said. And finally, the aspect that really was a bone of contention was that the court said a restriction on transferability of shares which is not in the articles of the company is not binding on companies or shareholders. So this was the principle, a very clear distinction between what was contractual and what was legal or what was regulatory. So and of course I can give you reference to various other cases even later and even until last year. But let's sum up what is the legal position for these two documents, that is articles and shareholders agreement, so that we can move on. So thus the provisions of the articles override the provisions of any private agreement between the shareholders. That's one. And however, do keep in mind that above all, the supremacy and overriding effect of the Companies Act is always there. And in cases where the shareholder agreement terms are incorporated in the articles, this debate really becomes little narrower, because the status of those rights are elevated to a statutory level. But where they are not incorporated, the debate still is raging. Now, keep in mind that just because a shareholders agreement is not incorporated in the articles, it does not mean that it's a useless document. It does not. It does not kind of impeach the shareholders agreement itself. So even if the terms of the SHA are not incorporated, it is enforceable between the parties as a contract under the laws of contract. That means you could, under the principles of contract law, go and either seek a specific performance or damages in a civil proceeding. That okay, there is a contract, it is valid in law, it has been breached, and I am here to proceed. It still has some kind of a protection or a enforceability. So thus a private agreement for preemptive rights, which does not bind the company because the agreement has no place in the articles, can be subject matter of a civil suit between parties to the agreement, and the party committing breach may be liable to damages. So that's broad interplay. That's the law. That's the ecology of the legal framework of shareholders agreement and articles. Now, moving to our subject of today, with these broad principles as the backdrop, we now come to shareholder rights valuation. That is the equity interest valuation. So how do, in our analysis of valuation, having reached at enterprise value, how do we now kind of transition to the shareholder value? Now, before I take that, you need to understand that what are the most critical shareholder rights relevant for valuation purposes. So let's identify those, and we have spoken about some of these. There are three very critical rights of shareholder rights which are relevant. Of course, there would be others, but the three are at the heart of it. That is the degree of transferability of the shares. Interface that with the degree of marketability of shares. These terms are used interchangeably at times, but they do differ at one level. And third is the degree of control attached to those shares. So these are the rights, existence, strength, weakness, presence, or absence of which will guide you through your valuation analysis of the shareholding block that you are dealing with. So let's with that, having identified those rights, now let's see in that context. Let's introduce the concept of discounts or premiums in ascertaining shareholder value. Now, once your EV is calculated by your one or more methods of valuation, it may be necessary to adjust that value to discount for minority interest, for lack of marketability, amongst others. So this is one of the statements from where Mr. Mark Kenter starts this analysis. There are two fundamental tools, you see, of valuation analysis considered after determination of EV. So these are two of the fundamental tools that you will encounter. You have to deal with, you have to analyze, provide for, adjust, or whatever. One minute, I'll just to see. Yeah, back to our. Sorry, there was some disturbance. Yeah, so two fundamental tools of the valuation analysis after which you need to look at it. One is discounts. Discounts which essentially reduce the value of the interest in closely held companies, usually minority interests when we are talking about. The opposite side of the coin, premium, which enhances the value of the interest. As we spoke earlier, such discounts and premiums are generally assessed, applied, considered towards the end of your valuation exercise. Though we do find that some analysts adjust for control of minority in the cash flows of the business. That's an aspect which the valuation experts would take you more deeper into. But what we find is that we approach this discounts premium at the end of your valuation exercise. Most common valuation discounts and premiums arise from the basic control of basic concepts of control and market. Of course, there are other concepts also. For example, key management appointment rights and all that. But control and marketability are the most common feature with which you are going to look at or assess the discount or premium or applied. Now, just to point this out, that discounts or premiums can be at an entity level. I mean, there are various ecological, environmental aspects surrounding a company or enterprise, and so the moment you approach, there could be discounts and premium at entity level or at the shareholder level. That's the internal level. Our discussion today focused on the shareholder level discounts or premium. We are not too much concerned about the business, industry, economy, and entry level aspects. So that's what we will do. Now, let's now pick up one aspect of these two, that is marketability of the equity interest and discount for lack of marketability. So DLOM is what we will now move on to. Now, I think it's again very simple, but it's useful to just kind of put it in some conceptual framework, that the concept of marketability in the context of security shares is essentially means the ease and timing within which a security may be sold when desired and at a representative current price. That means the speed and the ease with which an equity interest may be bought or sold. In other words, it is the ability to sell the interest and obtain cash quickly without loss of value. So this is the concept of marketability. Usually, we find that liquidity and marketability are used interchangeably. When we talk of the concept of this shares, but I mean, if we were to kind of look at very closely, they are not the same. I mean, we all know that anything liquid must be marketable, but the reverse may not always be true. That means you may have a interest or a security which is marketable, but it may not be liquid at that point. So, to that extent, there's a very nuanced kind of a difference between these two. Now, you see, let's understand. In the context of shares, transferability of securities is a great beneficial feature of incorporation of the company. As I said, transferability and control are there. And why is it so? Because you have invested, the investor has invested into the shares. He cannot now withdraw his money from the company. He can only convert his investment into cash by sale of the shares. Thus, incorporation provides a mechanism by which the company gets permanent capital and the shareholder gets liquid investment. So that's the little dynamics between shareholders and companies where, and so hence the transferability and the marketability assumes very great significance. And that's the reason why from very inception of the concept of public companies, free transferability of shares has been considered to be of very primary importance. We all know. I mean, we'll come to the law, but in the context of public companies, in the essence of the value of the shareholder, that his shareholding is freely transferred. Now, in that context, quickly let's look at what the Companies Act provides in the context of marketability. We all know Section 56 of the new Act deals with the transfer of shares. But before that, Section 2, subsection 68 provides that a private company can restrict rights to transfer its shares. All right. So that's provided in the law. It's in the statute that a private company may restrict transferability. That means may restrict marketability. We did mention that this restriction manifests itself in the articles of the private company, giving the board some kind of right to refuse to register transfer. Keep in mind there's a legal check there. Laws have imposed some kind of a legal bona fide restrictions. And on the other spectrum, we do have Section 58 of the Act, which provides that securities of members of a public company is freely transferable. So as I said, the salutary principle of free transferability of shares is codified in our it was there in the old Act and also in the new Act. So what's the effect? What's the effect of this? The way I see it, that under ceteris paribus conditions, that means other things remaining the same, publicly traded securities are more marketable than securities of closely held private companies. One. Two, securities with restrictions are generally less marketable than those without restrictions. Two principles very clearly come out from the legal framework. But also keep in mind the caveat. Free transferability is thus assured under the law. Companies may place reasonable restrictions on transferability. They do, in fact. In private companies, these are done to safeguard their family identity, close holdings, and all that. So these are upheld in law. Also, in public companies, we do find some regulations, from SEBI and all that, which prevent unscrupulous takeover control through market mechanism or operations. So these are in the nature of protective restrictions, which also have crept in, and to that extent they impact the transferability. So with that, so that's the marketability and the transferability aspect. Now let's see what conceptually does DLOM mean, and how does how does it interplay in the context of the marketability of shares, and what are the factors determine the value degree and the application of DLOM. So marketable ownership interest, as we said, is one which is reasonably liquid. That means it can be sold and converted into cash fast and at lower transaction cost. Of course, ready marketability enhances the value of the security and vice versa. So if it's a fairly marketable security, there is a value attached to that. Any ownership interest that does not have this quality is considered non-marketable. And in the valuation world, in the valuation analysis, non-marketable equity interest is valued by application of DLOM. So when you are dealing with non-marketable equity interest, that is the point that in your valuation analysis you would consider application of the discount for lack of market. So that's the space where DLOM creeps in. Now, quickly let's also look at that what are the factors that impact marketability and hence the level, degree, or the application of DLOM or the lack of it. So what are the things that are needs to be looked at when you are, from a law or a contractual perspective when you are considering deal? First of all, you would of course look at the terms of the articles attaching to the transfer of shares. That means if there are restrictive terms in the articles, then it will tend to enhance the deal. The second, as you spoke, you will look at the contractual regime surrounding the shareholding. What are the contracts to which the company or the shareholding is bound? So you will do that. Typically, these would be your shareholder agreements, pooling agreements, JVA, also your lender agreements. It's very, and we all know that the lender contracts fairly seek pledge of shares. They impose restrictions on transferabilities. There are various covenants there that you can do, you can't do. So you would analyze the entire contractual regime and see to what extent these impact the marketability of the shares. Another thing in the Indian context is very important is that you have to look at the pricing laws. We all know that there are FEMA pricing guidelines that say that you cannot transfer below this price and all that. There are floors and ceilings. So you have to look at the pricing guidelines. And that's another which will impact the how the shares could be and at what point they could be marketable and on what terms. Then, of course, put options. If you indeed find that there are put options, it's something very good because then if if such rights of put option is attached to this the security, you can put it to the other shareholder and legally compel him to buy it. It's a readily available market. So of course, very strong put options at times reduce or even eliminate deal. Then another aspect that you look at is the dividend payment kind of a profile of the entity. Generally, we find that high dividend leads to high marketability and hence low deal. So this is then again an aspect. Now, if there exist potential buyers of the interest. So you would analyze that industry, that company, the whole similar as, and you say that okay, there are potential buyers of this interest for various reasons. Then you will tend to reduce the degree of the deal. Another aspect that you look at is the size of the equity interest that you are dealing with. We all know that larger block, though it gets more control, but there are lesser buyers, and hence there could be an increased situation of a deal if the block is very low. Then you look at the future prospects. I mean, is the company, is an IPO is cited? Is the company, does it have a prospect of an IPO or a sale of business? Those kind of things are there on some credible basis. Then you would again tend to be conservative with your deal. Then, as we said, that restrictive transfer provisions, either in law, articles, or contract, they will again tend to, they're very restrictive, very severe. They will tend to enhance the deal. So, thus, restrictions in shareholder agreement, partnership agreement articles severely impact transferability of ownership interest and thereby require you to assess and apply deal. So that's the basic concept of how DLOM operates. Now let's pick up the other aspect which we discussed, that is control by shareholders and the features attaching to DLOC. That is discount for lack of control and how that operates. As we dealt with in the context of marketability and DLOM, we first try to understand what marketability means. In the context of DLOC, let's quickly, I mean, it's a very common term, we all know that, but let's quickly try and highlight what do you mean by shareholding control. Control to a block of or a group of shareholders, it relates to the control of the company's affairs. That means this shareholder group, block, or community has control over the destiny of the company. When I talk of destiny, I not only talk of key operational decisions, actions, plans, key functions, but also, you know, organic decisions. That tomorrow, if the company was to go on into some kind of rearrangement, some kind of buy, sale, some restructuring, the group of shareholders who control this, they really have really control they exercise and they are close with this kind of control. It's very common that the forums at which you would see such control operating, functioning, or being exercised are shareholder meetings, board meetings, and company management. That's where the control is visible. That's where you can the control is tested. That's where you would examine that what kind of control exists. Now, with that understanding of control, let's look at what are we talking when we talk of discount for lack of control. As we have said, control premium and DLOF are mirror images of each other. I mean, I need not expand that. If there is control, there will be a premium. If there is a lack of it, there will be a discount. Essentially, they're two sides of the same coin. And what we recognize is this, that controlling shareholders have some legal rights, some valuable legal rights, which make their shares more valuable than minority shareholders. So, as a valuer, you are identifying those rights and you are trying to put them together and recognize and provide for that by having these valuable rights, each block of shares have to be more valuable, or if they don't have it, then they have to be discounted. So, thus, owner of a controlling interest in a business enterprise has these valuable rights, which a non-controller may not have. So, there is some kind of a disparity, and hence valuation has to assess various elements of control or lack of control. And while control premium seeks to quantify the value of uh, control premium seeks to quantify the value of the controlling destiny of the company. So that's the premium aspect. Now, in the context of quickly, it will be important that in the context of how would you cite such control? What are the things that you look at when you are trying to enlist, define, or some kind of make your matrix of control and then go to assess it or value it? You look at, I can give you, it's a huge list, but let's kind of restrict to some of the big ass ticket items. You will look at these kind of rights attached to the shares. One, appointment or change in operational management. Does this shareholding value, does this shareholding block has this kind of right? Can it appoint or change members of the board, key management personnel? Does it have those kind of rights? Can it determine management compensation and perquisite? Then can they define or set operational and strategic policy and change the course of the business? Are such rights capable of being exercised by this block of shareholders? Then, of course, as we said, power to acquire, lease, or liquidate business assets, including plant, property, equipment, select suppliers, vendors, and subcontractors. Then consummate or complete mergers or acquisitions, liquidation, dissolution powers, can the power to declare dividends, of course. Can the shareholders can or the block can they alter the organic documents of the company, the memorandum and articles? Then can they alter the operations, product, service mix? Those kind of very critical uh, critical things which a company does. And keep in mind that within all this, one aspect is that the power of a block of shareholder to do these things enhance the control. On the other hand, if a minority block is a minority group of shareholders is able to block any of these decisions, either in law or through contract, then the control of the minority also gets enhanced. So always keep in mind, and we in law call it affirmative action, what you can do, and blocking actions. So test under both these parameters. A very kind of a very simplified spectrum of how control operates within the context of our Companies Act. It may be useful to look at it here, and how it functions at different levels of shareholding and at different levels of blocks. I mean, we all know 100% shareholding is a case of full ultimate control. Then the next level we look at is 76%, which is the case of supermajority. We all, I mean, these are very elementary concepts. Our section 114 of the new act does provide that certain corporate actions will require more than three-fourth majority. That means if a block of shareholder is holding 76% or more, it enjoys supermajority. The element of control will be very high, GLOC will be very low. The third level which you look at is a simple majority, 51%. When joint ventures shareholder agreement are negotiated, who will take 51%? A simple control. Majority of the operational decisions of a company can be taken at the board level. Board level, of course, it is always a simple majority, but they can be taken at the members level by a simple majority, 51%. So that's a very, very layman kind of figure of control. Very close to that is unfortunate situation of 50% shareholding. Very, very risky, usually leads to deadlock and triggers very, very adverse kind of a corporate action or disputes. I mean, in my legal career, the moment I have to deal with a company with 50% shareholding blocks, it's a nightmare. As I said, the next level we look at under the Act is your 26% shareholding. That means basically you can block supermajority. So there are certain very important decisions of a company which you control, which cannot happen by without your concept. And finally, we also consider that 10% is the threshold of any kind of credible control that you can enforce. And I say this because in the context of shareholder action in law, that is the nature of operation or mismanagement under section 244, we all know that 10% is the threshold. Really, if a shareholding is below 10%, unless it has very strong contractual rights under the SHA, may be embodied in the articles, it will lack control. It will even lack the power to enforce its rights in law. It will not be able to enter that door. So these are 6 shareholding levels at which we'll look at control under the Companies Act in law. So we have dealt with control now within a contract. We have looked at it within the law. As I said in the beginning, when you are assessing control or lack of it, and as a result, the necessity and the application of discounts for lack of control, you will look at the law, the contract, and the other aspects that we discussed. Now, broadly, just to, I mean, so if you look at it from a corporate view, there are 3 facets to the control. A blocking power, that is, you can block certain things at 26%, 51%, or 76%. That's one. Second is a swing vote. Basically, swing vote means where 2 minority shareholders can come together and vote to convert it to elect directors or create a controlling interest. And another facet is that there are takeover protections. in law or in the articles, it may be provided that if a majority shares are sold in a controlled transaction, the minority shareholder should be offered the same price, same terms. We find this embodied in our takeover code, the SEBI substantial acquisition shares and takeover code. So that's also that kind of gives the same extends the same opportunities to the minority. So what are the features? Now, have you looked at control? What are the features of? First, you apply to minority ownership interest or non-controlling ownership interest. We know what that control is. We have discussed about. Second, the application depends on three things: the level of value that is taken from, the legal and contractual documents that control the rights and restrictions of the interest holder, and the ultimate rate of return produced for the interest. So these are, the broad buckets in which if you look at. And finally, let's see what are the factors. I mean, you found this, but what will impact DLOC? When you're considering that, okay, fine, this is a situation where I need to look at DLOC, what should I? First of all, look for supermajority requirement in law or through contract like SHA. That's a box you need to take. Second is, at times, available judicial remedies may also reduce TLOC. That means things like minority shareholder action in law. Our Companies Act provides it. Fiduciary obligations of majority direct shareholders to the minority shareholders, or the fiduciary duties of directors to the shareholders. And if these are breached, then there are judicial remedies. So these would kind of say that, okay, control can be exercised, enforced through judicial remedies. So if the legal paradigm provides that, it kind of may reduce the DLOC. Of course, we spoke the terms of the articles, which will give you the related degree of control or lack of it by allocating rights between the shareholders. Then you will also look at the potential dilution that the share may suffer due to issuance of shares or redemption of any outstanding. So as we spoke, dilution at various levels will take you at various slabs of control and your effectiveness in deciding the key decisions. Of course, then you look at preemption rights. But are there any priority subscription rights, contractual restrictions? We spoke about that shareholder agreement, lender agreements, and these could be binding again. Then another thing will be that an overriding and a very simple factor is you look at the overall financial condition of the business. I mean, our discussion would be quite odious if the company's financial situation is not good. When control has little economic value or sense, so you will also kind of look at that. I mean, a factor that you would have been already cited in your early stages of your valuation analysis. Now, another thing that is there is which you need to look at is the degree of the regulated business. How much is the statutory control over majority action? Lot of laws control, that in various ways that a majority cannot roughshod or cannot wish away or cannot just scoot off the minority. If that is there, you cite it. Of course, the control the discounts will be lesser. And as I said, you look at the overall public-private company, the paradigm, because we know that the public companies, there are various SEBI regulations they are bound by. There are situations where there could be, although it's a private company, there are independent directors on the board, there are professionals on the board, and those are things you look at and you see that, okay, what is the degree of kind of protection that a minority shareholder has in this kind of company. Now, coming, so that's a broad kind of a summary around DLOC, DLOM, the legal framework, and the contractual paradigm. I will very briefly indicate that how do you approach the valuation or the quantification of the non-controlling interest. I will not go into the details of this because this is something that the valuation experts will deal with you or would have dealt with you. Broadly, there are the discount approach. That is, you apply the DLOC to the EV and you discount it. Then there is something called a direct comparison approach. Basically, you compare this closely held company with similar non-controlling interest in it, and then you make some deductions there. And then the third is, which we cite, is the income approach, where the economic benefit that a minority shareholder expects to realize over an expected holding period, determine that and discount it at an appropriate rate of return. So these are, I mean, textbooks talk about it. These are the ways that you would kind of quantify that. In my summary, I would not get more deeper into these aspects, but I would encourage at some stage for the team to take these up further with you. Now, finally, as I said that now we have spoken about DLOC and DLOM, we have some idea of how they are operating and how they are to be considered in law, contract, and in the regulations. Let's now try and put them together. Let's interface them and let's see, what is the how do the concepts operate qua each other or vis-a-vis each other. Now, first of all, generally, the empirical evidence to quantify DLOM is comparatively greater than those to quantify DLOM. So there are studies, there are empirical evidence, there are various research things. There are more in the context of quantification of DLOM than DLOM. Now, though the concepts of DLOM and DLOM are separate, I mean, you will assess, you will look at these. But as you would have definitely cited through this discussion, they are somehow interrelated. People who have control, also shareholder block who have control, would generally also control liquidity and market. So it is to that extent also interrelated to each other. So look at them in conjunction. Generally, the base from which DLOC is subtracted is the proportionate share of the value of the equity taken as a whole. So you take the proportionate share of the equity value, take it as a whole of that block, and then you subtract, then you adjust for DLOC. On the other hand, the base from which DLOM is subtracted is the value of an entity or interest, usually minority interest, that is otherwise comparable but enjoys higher liquidity. So just keep that distinction, as when you're dealing with this. Then at times, I mean, this is again something that you would have dealt with, that lack of control may be reflected in projected cash flows, whether or not control adjustment is made to the cash flows. I mean, that's one way that some valuation analysis they do look at lack of control. Now, I think I need to now go to completely the jurisprudence of on Indian law and international law, and then we will try to sum up. So I think this could be a useful time for us to break for today, and then take some questions, that we can address within the space of what we discussed today. Yes, I have a question here. Does SHA amendment will also require AO amendments? The way I would like to look at is that if your original SHA is incorporated into the AOA, good form and good corporate practice will require that the SHA amendment is also included in the AOA. Of course, the process of amending the articles is there in the Companies Act, by which you will amend the articles and bring the SHA into the articles. Third is that the amendment to the SHA itself may provide that you will amend the articles to include the amendments. So that's the answer. We have spoken about while applying DLOC, there are three dependents. Yes, we spoke of many dependents, in fact, while applying DLOC. We went through those. And I think that's it. What I can do is there are some questions. If there's anything else, it can be posted here, Dr. Siroi. I can address them in the evening, and then we'll resume tomorrow from where we leave. And thank you so much. Thank you so much for being patient and kind of sharing, listening to us. And we will resume tomorrow. Thank you.
Thank you, Ojha. Thanks for coming and joining us. Look forward. Some participants, some queries. Please hold them. Maybe we will address them tomorrow, friends. Ojaji will join us tomorrow also. So thank you, Ojaji. Thank you very much.
Thank you. Thank you so much, Dr. Siroi, and thank you, everyone. Good evening.
Good evening.